Handling an adoption for a client of mine is one of the most satisfying things I do. There are generally two kinds of adoptions. One, where relatives are adopting the child. Two, where it's a non-relative. Either sort of adoption, the first thing that must be determined if it's possible to terminate the biological parent's parental rights. Unless you are able to terminate those rights, you're not going to be able to adopt. There are two ways to terminate a biological parent's parental rights. The first way, when the person gives consent. If a mother and or father want to voluntarily give up their parental rights, there is a form that they can fill out, be witnessed by a South Carolina attorney, and that, in essence, allows their rights to be terminated. The second way that you terminate someone's parental rights is by involuntary termination. The law in South Carolina gives two primary grounds to involuntarily terminate someone's parental rights. They are if you have failed to pay child support for a period of 6 months, and or if you have failed to have meaningful visitation with a child for a period of 6 months. If you have either or both of these grounds, you have a basis to file to involuntarily terminate someone's parental rights. Back to the question of adoption. The most common adoption is a relative adoption. This may be a stepfather, an aunt, grandparent, some sort of relative adopting the child. If you're doing that sort of adoption, it's a much easier process because it's not necessary to have a home study done at the time of the adoption. Planning to adopt a child that you're not related to, then it is necessary to have a background investigation and home study done. I strongly recommend taking these steps before starting the adoption process. Adoption is a wonderful way to bring families together, and it's one of the most favorite things that I do in my practice. If you have more questions, please contact the Law Office of Brian Katonic at 803-644-5535.